You are Michelle Lee Cormier, and Ms. Cormier is charged with the first-degree felony offense of murder in cause number 25 DCCR 0153. Mr. Radford has filed.
Right away, this hearing turns into a legal chess match. The defense isn't arguing whether someone died. They're attacking the wording of the murder charge itself. And in criminal law, one missing mental state requirement can completely change a case. This is where courtroom strategy gets dangerous.
Motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder.
Judge, if I may, the common law has established that murder is when someone intentionally, knowingly causes the death of...
The statute is what we're going to go by.
Yes, ma'am.
Okay.
But I don't think it was the intention of the legislature to remove the requisite mens rea.
What makes you think that?
Because the common law going back 1,000 years has required murder to be intentionally and knowingly.
But they've added section B4, which it's a little confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers a controlled substance included in penalty group 1B. Well,
did you catch that? The judge zeroes in on one word, knowingly. That single term could decide whether this is treated like an accidental overdose or straight-up murder. Prosecutors love statutory wording. Defense attorneys love ambiguity. And right now, both sides think the law favors them.
Blah, 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 that's fentanyl, that's what the allegation is. And so it actually has the mens rea of knowingly deliver. It reads straight from the statute, so I'm going to deny that motion to quash.
Can I
Sure.
just make a brief argument?
Yeah.
Under this indictment, under the way that it's pled, if a doctor gives a patient fentanyl and that patient dies, then that doctor can be charged with murder even though he did not intentionally or knowingly.
Well, there's an exception. The next C, except as provided, well, where was it? I saw this. It is a defense to the prosecution under section B4, which is our section, that the actor's conduct in manufacturing or delivering was authorized under Chapter 481 Health and Safety Code or state or federal law, which I think would be the medical purposes. So there's an exception.
Is it my understanding then, is the court of the opinion that the state must prove that my client knowingly delivered fentanyl to an individual?
That's what the law says, and that's what the indictment says. Did then and there knowingly deliver a controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingesting and inhaling that into her body. So
that it's the opinion of the court that Ms. Cormier must have the requisite knowledge that she was giving her fentanyl?
I think that's...
Here. I think
Go ahead.
what Mr. Radford's trying to do is box the court in here.
I'm not gonna...
My interpretation of
This is the moment the courtroom tension spikes. The judge basically says the prosecution may only need to prove the defendant knowingly delivered the substance, not necessarily that she intended anyone to die. That's a massive distinction. And if you're on the jury one day, you're suddenly asking yourself, where does responsibility end? And murder begin?
statute is just knowingly deliver a controlled substance. And that controlled substance, if it contains fentanyl, is enough for her to be guilty of this offense. If it contains fentanyl and causes the death of a person, then that gets us to murder.
Well, I think that's going to be another whole question because it's specific that
it says knowingly
deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I don't think that's, I'm not going to make that decision. That's not a, I mean, that's just an element of the offense. So the motion to quash is denied.
Yes, ma'am. I would submit that the statute is unconstitutional as drafted.
Okay. I'm not going to find the statute.
I understand.
I'm going to follow it as written.
Yes, ma'am.
All right. So that's denied. Hold on just a second. Mr. Radford has also filed a motion to reduce the bond. Do you plan on calling your
Yes, ma'am.
client? Ma'am, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
For the purposes of the hearing, this hearing only, we call Michelle Cormier on the issue of bond reduction. Can you state your name?
Just so you know, once she's under, I mean, I don't let anybody go far, but if she's under oath, and I am allowed to take into consideration some of the underlying facts of the case.
Yes, ma'am.
We won't go far, but just don't want you to think that can't go there at all.
Yes, ma'am. I
Okay.
understand. Can you state your name for the record?
Michelle Lee Cormier.
And you are the defendant in this case, is this correct?
Yes, sir.
And your bond is currently set at $500,000, is that correct?
Yes, sir.
Can you afford a $500,000 bond?
Yes.
Do you have assets in your name that you could liquidate to make a bond?
My family does.
Your family can help you? Have you talked to your family about possibly helping you with the bond?
Yes, sir.
And how much, what kind of bond do you think your family can come up with?
100,000 or less.
100.
That's what all of them have told me.
100,000, you think they can make a $100,000 bond? Would it assist your case in the presentation of your defense if you were bonded out and could assist me in working on your case?
Yes, sir.
Where were you born?
I was born in Beaumont, Texas.
Okay, have you lived here how long?
I've been back down in this area since I was 13 years old, so.
So you pretty much lived here your whole life?
Yes, sir.
Notice how the tone changes instantly once bond reduction starts. The hearing shifts from pure law to pure risk assessment. The court now wants to know, does she have ties to the community? Money? Family support? Prior convictions? Judges look at all of that when deciding if someone is too dangerous or too likely to run.
You have family in this area?
Yes, sir. Jasper area, my aunt here in Beaumont.
Where would you live if you made bond?
The Golden Triangle, Beaumont, or Butter.
Who would you live with?
My aunt, my 83-year-old aunt that comes and sees me, or my son and his grandma in Butter. My aunt lives here in Beaumont, off of Major Drive.
If the court set conditions of your bond, including a GPS monitor and random drug testing, would you agree with that?
Yes, sir, I sure will.
What is your criminal history? Have you been to TDC before?
Yes, sir, I went for a burglary of habitation back in 2013.
How much time did you serve?
I made my first parole, and I served 2.5 on that 10 because they sent me to safety. And I successfully came off of parole July the 11th of 2023.
That's a witness.
I want to know, I'm trying to I think it's probably in this reply. What was Ms. Cormier in custody for
Or theft, if I'm not mistaken, Judge.
when this happened?
Yes,
Okay.
ma'am.
So the allegations here are that you were in custody for theft.
Can I rephrase that?
No,
Okay.
just
Okay.
answer her
Yes,
question.
ma'am.
In custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death that had fentanyl in it. Am I correct?
That's it in a nutshell, Judge.
All right, go ahead, Mr. Coleman.
And you don't disagree with the judge's assessment that you, in fact, smuggled fentanyl into the jail?
I'm gonna object to that. I think you said the allegations are, what he's trying to do now is bind her into a confession.
I'll move on, Judge.
Thank you.
While you were in jail, did you provide a controlled substance or substances to other felonies?
Again, Judge, I'm going to object that is not relevant at this time.
I'll move on, Judge.
Thank you.
Where did you get those drugs?
I'm gonna object at this time, Your Honor, to that.
I think any of those are going to go to her Fifth Amendment right against self-incrimination,
Yes,
Mr.
One last
Coleman.
question. When you were arrested on the theft offense back in November of 2024, did you have a pending felony drug case in Orange County? Had you been arrested for methamphetamine possession in Orange County?
Yes, ma'am. Yes, sir.
That's all I have.
What's the status of that case? Do we know?
Still pending as far as I know.
Okay.
I don't think it's been filed. If it's orange, it could
They're
take-
waiting on
It could take
drug
years.
testing. Okay, anything else?
No, ma'am.
No, ma'am.
All right, based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a reduction in bond. I think 500,000 is adequate based on the nature of all of those matters. All right, anything else then on this case?
No, ma'am.
Okay, we'll reset it for an announcement.
Thank you. May I be excused?
Yes, thank you.
Judge, for the announcement purposes, I am waiting on a report from my expert, and I anticipate that will be early June.
Okay, we'll just do a normal reset and we'll see where we are at that point. Thank you. You can go back with the bailiff. All right, so are you Howard Celestine? And Ms. Peraza, will your client waive the formal reading of the indictment in each case? Mr. Celestine, in cause number 24 DCCR 0919, you're charged with a third-degree felony offense of manufacturing or delivering a controlled substance from January 10th of 2024. That indictment alleges that you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And is that prior offense true, that prior conviction? The one that I read out, the aggravated sexual assault of a child, is that true, that that is a prior conviction of yours? Okay. And cause number 24, DCCR 1549, it says count one only, but then it says a 20-year term, so it has to be count one and
That's
two.
right. That was my intent.
If it's
That's
20,
correct.
count one and two,
Yes.
okay.
Oh,
There's only one prior.
right.
So that's what makes that third degree turn into a
The
second.
second degree. Okay. Sorry.
So pleading on count one would only be to the underlying offense.
Right.
Okay, so in 24 DCCR 1549, you're charged with a second degree felony offense of aggravated assault with a deadly weapon from June 24th of 2024. The indictment alleges that same prior conviction from April 13th of 2009. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And again, is that prior conviction true? And did you enter your plea of guilty in this case freely and voluntarily? And because you actually did what they've charged you with? So in cause number 24 DCCR 1550, you're charged with a first-degree felony offense of murder from June 24th of 2024, and the state's elected to proceed on that count only. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In cause number 24 DCCR 1551, you're charged in that case with the state jail felony offense of abandoning or endangering a child from June 24th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Peraza? Do you fully understand them? And do you understand if I follow the agreements that you've reached with the district attorney, you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Celestine is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true in the cases that you did freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas in each case. In cause number 24 DCCR 0919, find sufficient evidence to find you guilty, and at this time find you guilty of manufacturing or delivering a controlled substance. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 1549, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 1550, find sufficient evidence to find you guilty, and at this time, or find that you entered your plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 50 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 1551, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I am making an affirmative finding of a deadly weapon in cause number 24, DCCR 1549. I'm handing you in all of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff.